Listeners webinar, Creating and Living a Harassment-Free Environment. Your speaker for today's program is Robert G. Brody, Esquire. Bob is the founding member of Brody and Associates, LLC, a labor and employment law firm which represents management. Bob has been in private practice for over 25 years. In addition to providing daily counsel to management on labor and employment issues such as the new healthcare legislation, ADA, FMLA, workplace violence, and alternative dispute initiatives, Bob represents employers before federal, state, and local civil rights agencies and in court. Operator assistance is available at any time during this conference by pressing #. If time permits, we will accept questions following the presentation. You may send chat questions at any time during the presentation using the chat window located to the right of the presentation. I will now turn the call over to our speaker. Bob, please begin.
Thank you. Good afternoon, everyone. We're going to be talking about harassment-free environments. You're going to find that most of our conversation is going to focus on sexual harassment because that's the most well-developed area. But you are also going to find that when you take those principles, they apply to all kinds of harassment. So let's take a look at our agenda for the day. In terms of why are we here? Well, there's really two reasons. Some people have state-mandated requirements for training. At this point, I don't think anyone on this call is using it for that purpose. Many states require 2 hours. This is an hour-and-a-half program. There are about 4 states in the United States that require it. So that's one reason to do this. The other is obviously see what we can learn about maintaining a harassment-free environment and being in front of the wave instead of behind it. So we're going to learn a little bit about harassment, what it is, sexual, racial, all kinds of harassment. We'll talk about retaliation, and we're going to talk most importantly about what you can do to avoid those issues. As we go, you heard already from the operator, we have chat opportunities. And that simply means if you have a question, you can ask them at any time. I will try to pick them up as we go. Sometimes I'm able to, and frankly, sometimes between the conversation we're having and the number of chat questions, I really can't get to all of them. But I'll do what I can, and at the end, I'll also scan through the chat questions if I can to try to pick some ones up that I may not have answered as we have gone through the program. Okay. So let's take a look at first. The first thing we're going to do is we're taking cases that are from across the United States. One thing you should all know, there are both federal, state, and local laws that are relevant for you. While the basic principles are really pretty consistent, they do change state to state. As a practitioner, I wouldn't worry about the differences. As a lawyer, we do, because there are some ways we can get out of certain things in certain states because of the way that particular state law is, and another state may not read the law the same way. As a practitioner, we want to just have some best practices. We follow the best practices, we should be fine. So first, here's some real-life examples. What we're going to show you here is we're going to show you a case. We're going to talk a little bit about the case, and we're going to try to figure out, is this harassment? First question, I want you all to answer for yourselves. And then the second is there liability? And what I mean by that is, do you think the company was hit for damages, money damages? And we'll go over that just to give you some real-life perspective. Okay, Weeks versus Baker and McKenzie. You may know Baker and McKenzie is a very large law firm. They had a big Chicago office. They also had a San Francisco office. What you're going to read about here happened in San Francisco. And the individual who was the harasser was a very, very successful real estate partner who brought in a tremendous amount of business for the firm. So they hired a secretary to work with him in July. Among other things, this lawyer grabbed her breast, buttocks. He put his knee in her back, kind of pulled back her arms. He asked her, obviously, inappropriate questions about breast size. He was asking her intimate questions about her sex life in terms of what's the craziest thing, wildest thing you've ever done. In the face of all that, she does go to management. They transfer her away, And she says, you know what, I can't take it here anyway. I don't care. She quits. So she starts in July. She's got July, August, September. That's it. All right. First question for you, was there harassment? Yes. And then in terms of liability, as you can see, this is the interesting part. Compensatory damages. That's really what when you say, I've been hurt somehow or other, compensate me specifically, and usually it's lost wages, lost insurance, that kind of thing. So she got $50,000. Not a lot of money, frankly. But as you can see, $6.9 million in punitive damages against the law firm. We cite this case because one of the key issues here is a lot of times people will think, well, it's a secretary, she's not making a lot of money, it's not going to be a big damage case. That's true in terms of compensatory damages because she doesn't, relatively speaking, he or she probably isn't making a huge salary. But this case is an example of where a jury was clearly told by the plaintiff's lawyer, the lawyer for the one who was suing the company, let's send a message. Let's not let this big bully pick on this poor woman and get away with it. If you charge him, find him guilty of all this, that really sounds very criminal when we say guilty, but that's really the way this case would have been portrayed. If he's guilty of doing these bad acts, you got to send a message. You can't hit him for $10,000, $20,000, $30,000. So what they actually did was they looked at what the firm's net income was in the year. And they said, we're going to hit you for 10% of your net income. That way, it makes sense that they're going to send a message that we're not going to let an employer get away with his conduct for some small penalty. And that's exactly what they did. $6.9 million. Now, another interesting thing, $225,000 in punitives against the harasser. A big part of the case you should all keep in mind is if your company is ever involved in this, there are probably going to be two defendants. One is the company. The other may well be the actual harasser. And what the courts are doing, again, to make sure they drive home this message, they are often allowing a jury to say, I want this much to come from the company and that much to come from the harasser. And the harasser cannot get a bonus or a salary increase or anything like that to make up for what the penalty is. So in other words, they want him to take $225,000 out of his pocket and give it to her and not let the firm pay him back. And that's what they do. Now, the other piece of this, which is fascinating, and this is just the business of law, $1.8 million in attorney's fees. One of the reasons plaintiffs love to sue under the Civil Rights Act, Title VII, is because there's a provision that says if you win, you can get your attorney's fees. And as you can see, $1.8 million in attorney's fees. Big case.